Hi, everyone. My name is Elspeth Kaiser-Derrick, and I'm a PhD student at UBC in the Faculty of Law. I'm a lawyer at the BC Bar, too, but I don't practice. If anyone's having any difficulties with volume, just give me a signal and I can speak more loudly. So I've chosen to modify my intended presentation. So judicial sentencing discourses will be part of... No, what news? What news?
What just happened on Tuesday?
Okay, so Kim...
what you did.
I'm going through the comprehensive examinations, or I have just finished the comprehensive examinations phase, and Kim Pate is a member of my committee, and I just passed with distinction, so that's nice. Okay, so I've chosen to modify my intended comments. So judicial sentencing discourses will be part of, but not the focal point of my comments. I'm going to focus primarily on political discourses, and I'm going to foreground conditional sentences. I've decided to discuss political discourses because there's been such a barrage of new criminal justice legislation over the last several years, and I wanted to comment on the changing sentencing landscape. Judges aren't sentencing in a vacuum. Initially, I had planned to discuss my LLM work, which I did at UBC as well, about judicial sentencing discourses, and to comment on some judicial reasoning that's individualistic and fails to properly consider the sentencing of Aboriginal women within systemic factors. I'll still make limited comments on this later. And when I did a run-through, and it took me about 37 minutes or so that's just a gauge for your physical comfort and needs for my presentation. We'll have some time for discussion after. First, though, I wanted to engage with some of the discourses that run underneath the legislation that judges are dealing with. Sentencing judges are working within increasingly restrictive laws, and this will continue to detrimentally affect criminalized Aboriginal women and to exacerbate already rising levels of overrepresentation of Aboriginal women in the criminal justice system at large, and prisons in particular. My main point in discussing the following political narratives is that criminalized Aboriginal women do not fit within primarily conservative party views about who victims are and who offenders are. Because they don't fit into this narrative, and because this narrative grounds and lies behind recent legislative amendments, Aboriginal women are not meaningfully contemplated by this legislation and are in continued risk of increased criminalization and overrepresentation. Across the history of women's imprisonment, the knowledge produced about and constructions of criminalized women and women prisoners have significantly influenced how they're regulated. For example, regarding creating choices, the report by the task force on federally sentenced women from 1990 that really galvanized the movement toward ostensibly women-centered corrections, it has been argued that the task force failed to fully define, consider, and provide for women that are deemed difficult to manage by correctional administration. So without this guidance, CSC has been in a position to determine how to deal with these women. For women deemed unmanageable, perhaps due to mental health difficulties, problems with institutional adjustment, and/or women using violence inside, the lack of prescription for their custody has meant that corrections can use intensified measures of security and control under their own administrative direction. This can take many forms, but would include segregating women who are in distress and self-injuring. It is also specifically dangerous for incarcerated Aboriginal women. Former federal prisoners and members of the 1990 Task Force on Federally Sentenced Women, Fran and Lana, explain that this is a quote from them, "To be a woman and to be seen as violent is to be especially marked. And for Aboriginal women in particular, the label violent begets a self-perpetuating and destructive cycle. And the prison regime reproduces the violence that it's supposedly designed to manage." I want to frame my discussion of the following political narratives with the idea that how the political, court, and prison systems understand the women under their purview and control has ripple or tidal effects in the women's lives on their trajectories through the system. The way that political actors, judges, and penal professionals understand criminalized women has real effects on the conditions of their sanctions and certainly incarceration. I'll begin by discussing some narratives that recur in various parliamentary debates over bills that have since passed into legislation. The debates I'll discuss are Bill C-9, which came into force in 2007, the first of two waves of amendments restricting the availability of conditional sentences; Bill C-10, the Safe Streets and Communities Omnibus Bill, which among other changes further restricted the conditional sentencing regime; Bill C-25, the Truth in Sentencing Bill, which came into force in 2010 and largely eliminated 2-for-1 sentencing; and Bill C-37, the Increasing Offenders Accountability for Victims Act, that entered into force in 2013 and removed judicial discretion to waive victim fine surcharges on sentencing and also increase the fine amounts. I want to note that the Supreme Court ruled in April 2014 that judges can give double credit for time spent in remand, and there has also been judicial pushback about the mandatory victim surcharges, among other resistance to the government's law and order agenda in the courts. I found that across all of these debates, there was a running theme about victimization, and it primarily came from Conservative Party members. I'll start by discussing how this theme manifests in the debates, and then I'll move to discuss ideas about criminalization that arise in the debates, particularly as that relates to Aboriginal women. My larger point in discussing these issues, the refrain about victims and ideas about criminalization, is that, and it's again largely Conservative Party members, that they set up a false dichotomy between victims and offenders, which contributes to their utilizing a narrow, simplistic view of criminalization. And I suggest this leads to problematic legislation that makes marginalized people, especially Aboriginal women, more vulnerable to criminalization. First, I will outline how this largely conservative narrative about victims is featured in the debates. So I'm going to be quoting pretty extensively through this. Conservative member Rob Moore sets out that Bill C-9 will look at crime from the perspective of the victim. In the same debates, conservative Vic Taves suggests the bill is a movement away from constantly giving all the rights to criminals. In March of 2014, Vic Taves was appointed a judge of the Court of Queen's Bench of Manitoba, which only further underscores the need to pay attention to narratives that run through the parliamentary debates. Daniel Petit, another Conservative member, states victims are the whole reason behind Bill C-9. Vic Taves says about Bill C-10 that it builds upon the government's already impressive track record of cracking down on crime and standing up for victims. Multiple Conservative members state in the Bill C-10 debates that they stand up for victims or stand with victims, and using that language. Conservative Senator Pierre Hughes Boisvenu states that victims of crime and their advocates unanimously support Bill C-10. In the Bill C-37 debates, Conservative Rob Nicholson, who was the then Minister of Justice and Attorney General of Canada, states, "We committed to Canadians to put the rights of victims first, and after passing 20 justice bills since 2006, we have delivered." Carrie Lynn Findlay, another Conservative member, said in the same debates that for too many years, our criminal justice system was going in the wrong direction. It focused more on the rights of the criminals instead of the rights of the victims. Those quotes are only a sampling from the debates. From reading the debates, despite the largely conservative refrain that the various bills are rooted in concern for victims, they never seem to define who constitutes a victim. It is clear from comments throughout the debates that Conservative members suggest that victims and offenders are mutually exclusive categories. For example, in the Bill C-9 debates, Conservative Myron Thompson says, "I think when we focus on them, victims rather than criminals, we have a different view." He later says, "I really get personally tired of constantly saying, 'What about the offenders?' and comments, 'We cannot let the perpetrators who violate our laws gain any more inches. They've gained enough.' That's the direction we want to move in with this kind of legislation." He repeats, "I get tired of hearing about what we're going to do to protect the criminal. To hell with the criminal." Daniel Petit, a Conservative member, says everyone seems concerned about outcomes for offenders, but no one seems worried about the good people and the victims. The good people and the victims. Conservative member Rick Dykstra says victims matter most. Conservative Daniel Lang comments about Bill C-10 that it brings in a philosophy that says the rights of victims come first. Conservative Vic Taves says Bill C-9 is concerned about victims and it's a movement away from constantly giving all the rights to criminals. And I again want to note that he's a judge now. In the Bill C-10 debates, the then Minister of Public Safety for the Conservatives, Vic Taves, suggests victims are law-abiding Canadians. Rob Nicholson and Carrie Lynn Findlay both indicate that the Conservatives stand up for law-abiding Canadians and victims. Altogether, because such comments create a rigid dichotomy between victims and offenders, the effect is that the Conservatives are implying that offenders cannot also have histories and experiences of victimization. I wanted to present this to illustrate that Aboriginal women who often enter the criminal justice system with experiences of victimization connected to colonization do not fit within this dichotomy. And further, because this dichotomy drives the various legislative amendments, this framework precludes meaningful consideration for Aboriginal women in terms of their experiences, their needs, and how such legislation is likely to affect them. Broadly, this construction of a false dichotomy between victims and offenders reflects the conservative conception of how people are criminalized. I'm going to move here to briefly outline some comments, again from Conservative members, that reflect and suggest their views on criminalization. In the Bill C-9 debates, Helena Gergis states, "Our system has to be changed so criminals cannot treat our justice system like a revolving door." In the Bill C-10 debates, Conservative David Takchuk comments, "Logic will tell you that rational individuals think about their own consequences." Referring to the victim fine surcharge in the Bill C-37 debates, Conservative David Wilkes suggests, if offenders do not want to pay the victim fine surcharge, then they should not commit crimes. Yeah, it's easy. In those debates, Conservative Ryan Leaf comments, the NDP members talk about how poor and underprivileged offenders are, as if there is no rich offender on the planet. In response to concerns raised in the Bill C-37 debates about the interrelationship between poverty and crime, Conservative member Robert Sopuk responds that he found these comments very insulting to Canadians who live on low incomes. It is almost as if people who have low incomes are automatically guaranteed to commit crimes, which is appalling. And he goes on to indicate that there are many low-income constituents in his region with a low crime rate. And to explain that low crime rate, he says, I would argue that those people have the right values. Comments such as these suggest that people become offenders through rational choice, based in personal values, which fails to recognize the systemic issues that provide the context for many criminal acts. This thinking is problematic. For example, Michael Jackson and Graham Stewart have suggested that corrections viewed Ashley Smith through a lens of power and control and believed that her non-compliant and self-destructive behavior was a matter of choice. This kind of institutional framework, the belief that criminal behavior happens through rational, autonomous choice, unencumbered by systemic factors, means that the role of the prison today, the role of the prison in producing Ashley Smith's distress and in producing distress in other prisoners is hidden, and then justifies punitive, security-based correctional responses. This decontextualization becomes particularly problematic for Aboriginal women, whose offenses must be situated against colonization and often considered with reference to their histories of victimization, which means living within constrained choices. This requires more complex political and legislative understandings of what choice and agency actually mean. I'm going to move to discuss, again, primarily conservative comments about Aboriginal peoples from the debates, focusing on women where possible. My overall point in this part of the discussion is to highlight that because the conservative false dichotomy set up between victims and offenders and the decontextualized representation of lawbreaking, frequently discussion about criminalized Aboriginal peoples in the debates has effectively served to bolster the victim narrative instead of a true engagement with the anticipated effects of each bill, now legislation, on Aboriginal women. In the Bill C-9 debates in particular, Conservative members repeatedly suggest that the bill will be actively helpful to Aboriginal peoples. For example, Conservative Jay Hill acknowledges concerns raised about the impact of Bill C-9 on Aboriginal offenders, including concerns about it exacerbating overrepresentation in prison. And his response is to say, a significant aim of Bill C-9 is the promotion of more peaceful Aboriginal communities. In Canada, it is true, Aboriginal people are overrepresented as offenders. Also true, however, is that Aboriginal people themselves are overrepresented as victims. He adds that the restriction of conditional sentences for serious offenses is necessary in the protection of all communities, including Aboriginal communities. In response to specific concerns raised about the overrepresentation of Aboriginal women in the system, Pierre Lemieux says, while I thank the honourable member for her comments and thoughts, particularly on how this bill applies to our First Nations people, my concern is that this particular bill is for all Canadians. This particular bill is to get tough on crime for all Canadians. In the Bill C-10 debates, Conservative Bob Runciman acknowledges concerns raised that without an exemption from mandatory minimum sentences, Bill C-10 will deepen the over-incarceration of Aboriginal peoples. But his response is, it's important to note that Aboriginal peoples are also overrepresented in the criminal justice system as victims, and Bill C-10 will help all victims. I wanted to point to these comments to show how concerns about the overrepresentation of Aboriginal peoples in the system are neutralized within a narrative that focuses on victims and characterizes victims as distinct from offenders. Essentially, all of the quotes that I just shared follow the same pattern. Concerns about the overrepresentation of Aboriginal peoples are presented, and in these instances, Conservative members have suggested that because Aboriginal peoples are also overrepresented as victims, that they too will be protected by legislation that purports to be victim-oriented. This is simplistic, reductionist, and involves a flattening of victims, and fails to recognize how colonization continues to be a factor in the overrepresentation of Aboriginal peoples as victims. And it again fails to recognize that there's often no clear distinction between victims and offenders by not considering the victimization histories in the lives of many Aboriginal offenders. Overall, in discussing these debates, I've selectively pulled out quotes from Conservative members. I want to be clear that these are certainly not the only voices in the debates. There are much more complex understandings of criminalization represented in the debates which do consider systemic factors, but from members of other parties. I've focused on comments from Conservative members here because on my reading of each of the debates, I found the Conservatives tended to be having a completely different conversation. On my reading, it seems the Conservatives are suggesting that these bills are rooted in concern for victims, and so I think it's useful to unpack the narratives that are driving the legislation from the majority government. The victim narrative is prevalent, and I've discussed it largely in terms of its lack of nuance and contextualization. I also want to note that at times it involves more blatant misinformation. For example, in the Bill C-10 debates, Conservative Vic Taves references that the rate of reported crimes is going down, and the explanation he provides for this decline is to say that many people have simply given up on trying to deal with the justice system. Obviously, another possible explanation, though, is that reported crimes are dropping because crime rates are actually dropping, but that gets absorbed into the victim narrative. So these are not the only discourses that are running through the debates. There's much pushback from other parties about these narratives. For example, a few Liberal members suggest that Bill C-10 will actually create more victims, and an NDP member suggests the same about Bill C-37. This is a very different conceptualization of victimization than I've described from the conservative discourse. In the Bill C-10 debates, Liberal member James Cowan challenges the Conservatives on what he describes and what I've described as the false dichotomy of victim versus offender, because he says the evidence is that there's often no clear line. Far too frequently, offenders, in fact, used to be victims. Other party members seem to offer nuanced views on victimization and criminalization. For example, in both the debates for Bill C-10 and C-37, several members, none conservative, quoted Kim Pate's testimony to the respective committees about the prevalence of histories of abuse among women and Aboriginal women in prison, and how many of these women may be incarcerated for defending themselves or reacting to violence. In the Bill C-37 debates, Green Party member Elizabeth May contributes that not all of the victims are outside of our prisons. Some of them are inside of our prisons. NDP member Marie Charette-Poulin references the prevalence of histories of abuse in the lives of criminalized women and states, here the line between victim and offender becomes blurred. What we see are offenders who are themselves victims of crime. Liberal Lillian Dick, who I believe is actually at this conference and spoke this morning, notes in the Bill C-10 debates that the criminalization of Aboriginal women stems from intergenerational trauma from colonization. Many members in the Bill C-37 debates in particular comment on the role of poverty in criminalization. Senators in the Bill C-10 and Bill C-37 debates express concerns about how specifically women will be disproportionately disadvantaged by the legislation. So again, those voices are in the debates too, and sometimes quite prominently and effectively, but of course all of the bills have been passed into law. I'm going to move to discuss the sentencing of Aboriginal women. I wanted to discuss this against the largely conservative discourses relating to victimization and criminalization in the various debates, just to provide some context, because particularly for many Aboriginal women in the criminal justice system, it's necessary to consider their criminalization with references to their experiences of victimization. That is, I've suggested that the victim and the offender, represented by mostly conservatives in the debates I've discussed, are restrictive, mutually exclusive categories, and criminalized Aboriginal women do not fit within those categories. Law may seem to be neutral, but it comes from a place, and certain ideologies are embedded in it and carry through it. Just quickly before discussing sentencing, I want to first note various comments, again by conservatives, about what conditional sentence orders signify. In the Bill C-9 debates, conservative member Daniel Petit comments, conditional sentencing was not introduced in the criminal code in order to allow offenders charged with serious crimes to serve their sentences with their feet up at home, adding such situations are not rare. He repeats this sentiment, saying, when we have people who should be incarcerated but are sitting at home with their feet up, our system is not working. Conservative Gary Goodyear says about what he calls house arrest, let's call it what it is. He was sent home to watch DVDs, drink beer, and eat popcorn. Conservative Jay Hill suggests conditional sentences are get-out-of-jail-free cards and asks, how is that fair to the victims and their families when the criminal can go home, put his or her feet up, watch color television, and serve out the time with a bracelet on, adding, it's ridiculous. Vic Taves suggests conditional sentences mean they get to go home, lie on the couch, and serve their sentences there. Conservative Rob Moore suggests the same, stating, these individuals are going to serve sentences right in front of their own TVs, in the comforts of their own homes and on their sofas. That's not justice. So from this, I guess that for the conservatives, television watching is the greatest injustice. Vic Taves says, in these cases, he says the cases say they're serving a sentence of imprisonment in the community. Everybody knows that's a charade, and I think that's the kind of language that brings the administration of justice into disrepute. And again, I'm selectively quoting conservative members here because I found such a significant disparity in how they would characterize conditional sentences compared with how other parties represented them. In terms of representations of judicial discretion in the Bill C-9 debates, There are frequent references by members from the NDP, Bloc, and Liberals that the Conservatives do not trust the judiciary, comments about the importance of individualized sentencing, and judicial discretion on sentencing. On my reading of the Bill C9 debates, I found that typically where Conservative members did discuss discretion, they were emphasizing the utility of prosecutorial discretion, as if prosecutorial discretion can be supplanted for judicial discretion without that changing the meaning or impact of the decisions made through that discretion. In those debates, the Bill C9 debates, prosecutorial discretion was relevant because that wave of amendments to conditional sentences involved offenses prosecuted by indictment, which can involve decisions at the prosecutorial level. But prosecutorial discretion is profoundly different from judicial discretion, including because it does not involve the same safeguards of independence and because it's not subject to challenge and review in the same way that judicial decisions are. For very brief background, before I move on, most of this discussion emerges from the following. Emerges from my LLM thesis, which I submitted about a month after the most recent and now current amendments to the conditional sentencing regime entered into force in late 2012. In my thesis research, I reviewed 91 decisions involving the sentencing of Aboriginal women, and where possible, I focused on those where conditional sentences were either sought by counsel or otherwise considered by the judge. I wanted to mention this because, again, just before I finished that work, the availability of conditional sentences was further restricted through another wave of amendments. Conditional sentences were initially added to the criminal code as part of extensive amendments to the sentencing regime in 1996. And the availability of conditional sentences as a sanction was first amended in 2007, and then again in 2012. In my view, that's an extremely short time frame for 2 rounds of substantial amendments. The 2007 amendments came through Bill C9, and the 2012 amendments came through Bill C10, both of which I discussed earlier in terms of the problematic ideological claims about victimization and criminalization. At this point, conditional sentences are extremely limited, which can have particularly troubling consequences for criminalized Aboriginal women, who are often imprisoned for more violent offenses, who experience more periods of incarceration, and whose experiences of prison are often more punitive. My study was qualitative, not quantitative, but I did assess the projected impacts of the current legislation, the version that's been in force since late 2012. Of the 91 cases I had reviewed, which spanned from 1999, when Gladue was decided, to 2011, the date of my study that I started searching, 31 of the Aboriginal women sentenced were given conditional sentence orders. So I looked at 91 decisions in total, and of those, 31 Aboriginal women were actually ordered to serve conditional sentences. I looked up each of the most serious offenses from each judgment with reference to the recent 2012 amendments. And of the 31 conditional sentencing orders made in those judgments, within the current law, the legislation entering into force in 2012, 29 of those 31 conditional sentence orders would no longer be possible, either directly on the law or based on whether the Crown proceeded by indictment or on the facts. Or whether the Crown proceeded by indictment on the facts. For one additional case, I was not able to determine whether a conditional sentence order would continue to be available under the current law. Only one decision out of that 31 that actually resulted in a conditional sentence order would continue to be eligible for a conditional sentence order after the 2012 amendments. That means that those 29 to 30, because again, I couldn't determine for one of the women, so 29 to 30 of those Aboriginal women would likely be incarcerated under the current law. In limited cases, a strict probationary term may have been ordered instead under the current law, but I expect that a much greater proportion would be serving prison terms. So for the parliamentarians that characterize conditional sentence orders as being served with your feet up and watching TV, and who offered very restrictive, reductionist characterizations of who victims and offenders are, it's people like these Aboriginal women who are increasingly vulnerable to imprisonment. I wanted to start with that just to illustrate the stakes of the amendments restricting the availability of conditional sentences. A few judges in the cases I examined specifically commented on the unavailability of conditional sentences due to the amendments, with the implication that they may have come to a different result otherwise. I used conditional sentences to orient my work because I believe they're critical as a meaningful alternative to incarceration. I believe they're particularly important for Aboriginal women in the system, who are vastly overrepresented in prison at the provincial level as well as the federal level. There are many reasons for the importance of the availability of conditional sentences for Aboriginal women, including so as not to further deplete and fracture Aboriginal communities, in part because women in the system often have children and primary caregiving responsibilities. It only exacerbates long-standing intergenerational effects of colonization to incarcerate Aboriginal women and separate them from their children. I mentioned that conditional sentences were first introduced in 1996 as part of a broader codification of the sentencing regime. It's important to regard conditional sentences with reference to what has been called the restraint principle in sentencing. I'm referring to sections 718.2d and 718.2e. Section 718.2d states that judges should order less restrictive sanctions where appropriate, and section 718.2e indicates that judges should order imprisonment as a last resort where reasonable, and particularly for Aboriginal offenders. Even though the conditional sentencing regime has been amended since its 1996 form, those two other provisions, the restraint provisions, have not. So that means that there's a continued legislative direction to judges to reduce over-incarceration, but with restricted means of actually complying with that direction. I believe that conditional sentences are critical to the effectiveness and integrity of section 718.2d and e, because without real alternatives, those sections lose their power to reduce over-incarceration. In my work, I focused on section 718.2e and its implications for criminalized Aboriginal women on sentencing. The Supreme Court of Canada interpreted this section in the 1999 decision, R versus Gladue, which I'm sure all of you are familiar with, to give it greater clarity. Essentially, the Supreme Court held there that the overrepresentation of Aboriginal peoples in the criminal justice system, and particularly its prisons, is a national crisis. In light of that crisis, the Supreme Court directed that sentencing analyses under section 718.2e mean that judges must sentence Aboriginal offenders differently, involving a change in the method of analysis. They interpret that section 718.2e suggests imprisonment may be a less appropriate or less useful sanction for Aboriginal people. The implication of this could be an alternative sentence or a reduced sentence, so diversion or mitigation. The court held that section 718.2e involves an analysis of systemic and background factors related to each Aboriginal person coming before the courts, and how their Aboriginal heritage or connection should influence the form of the sanction. Recently, in 2012, the Supreme Court decided another case called R versus Ipoli, which is mentioned in the presentation before me, that added force to the Gladue decision. In Ipoli, the Supreme Court found that courts have been hesitant to take judicial notice of the relevant systemic or background factors. And the Supreme Court emphasizes that courts must take judicial notice of these factors related to colonization. The Ipoli decision also indicates that some courts have interpreted Gladue incorrectly by suggesting that an offender must establish a causal link between background factors and the offense for which she's being sentenced, which Ipoli clarifies is an inappropriate approach. Ipoli also found that courts had not been applying Gladue principles in a consistent way for serious or violent offenses, and that some courts were wrongly interpreting this to mean that Gladue principles do not apply to serious offenses. The court in Ipoli emphasized that judges have a duty to apply section 718.2e and to consider Gladue factors. I've given this background into how judges are to sentence Aboriginal offenders within the Gladue analysis because in my work I tried to examine sentencing decisions to determine how judges were considering Gladue factors for Aboriginal women, and particularly how this related to how judges interpret and use women's histories of victimization in their reasoning. I'll speak briefly about feminist theories about victimization and criminalization. There are various ways that different feminist work seeks to understand the relationship between women's experiences of victimization and how that impacts her vulnerability to criminalization. I found it helpful to think about the criminalization of women, not all, but many, through considering how their experiences of victimization have reduced the range of available options and choices. The phrase, the victimization-criminalization continuum, is one of the various names for this branch of feminist theory. I volunteered at a crisis line for women dealing with abuse in Vancouver, and the women on the other end of the phone often have very limited options, whether they stay in the abusive relationship or attempt to leave it. For women who leave abuse, they may have nowhere to go. Perhaps their partner isolated them from support networks. Maybe their own families condone the abuse. Maybe they're financially dependent on their abusive partner. Maybe they have a physical disability or mental illness or disability and are reliant on their partner for support and caregiving. Maybe the women are afraid of losing their children to the state or to their partner if they leave, and often there is inadequate transitional housing to assist in the beginning, among other barriers. And if women do leave the relationship, they're at the greatest risk of increased violence or being killed. So these are certainly not the only ways that victimization can manifest in women's lives, and victimization is certainly broader than partner violence, but it's an illustration of the constrained options that are available to women dealing with victimization, which can make them vulnerable to criminalization. Often where women use violence, it's in the home, and the type of violence is typically more self-defensive than the violence used by men. For Aboriginal women, experiences of victimization are shaped by processes of colonization. Aboriginal women are at greater risk of experiencing violence than non-Aboriginal women, including particularly high risk of partner violence and of the more severe forms. They may feel deep reluctance to seek, even fear of seeking, protection from police and legal authorities because of negative personal experiences with these agents and systems, and also because of a general mistrustfulness of the same systems that have long oppressed Aboriginal communities. Systems of authority that Aboriginal women may regard as illegitimate for being forcibly imposed through colonialism, such as state forced relocations to reserves, residential schools, state apprehension of Aboriginal children, and criminalization. These are just some of the ways that colonization is experienced in a gendered way. And it's against this backdrop that rates of incarceration of Aboriginal women continue to rise. The conservative political discourses I discussed earlier are far too narrow and dichotomized to understand criminalized Aboriginal women within these terms. Patricia Montour has explained that criminal behavior by Aboriginal peoples cannot be reduced to individualistic understandings, but must be contextualized within colonialism. This contextualization is what Section 718.2e and the Gladue analysis are intended to do. It gets tricky, though. Tony Williams has demonstrated that this contextualized analysis of criminalized Aboriginal women on sentencing may become connected to considerations of risk, which has different implications than the goal of reducing the over-incarceration of Aboriginal people. Sometimes the implications of that can mean judges sentencing women to federal incarceration in the belief that they'll benefit from treatment there. And other times it can mean simply sanctions of increased punitiveness. Further, the lens of risk may even be inappropriate culturally and conceptually for Aboriginal women. Patricia Montour-Agnes has written that risk management does not align with her Aboriginal knowledge and understanding about relationships. Tony Williams writes that the way the sentencing courts use Section 718.2e, it translates into claims about, this is a quote from her, it translates into claims about Aboriginal women with a simple narrative that constructs Aboriginal families as incubators of risk, Aboriginal communities as containers of risk, and the prison as a potential source of healing intervention. The cases that I analyzed in my work often lined up with this analysis. Overall, the sentencing decisions I analyzed varied in terms of how judges engaged with the Gladue analysis and how judges interpreted the women's experiences of victimization against it. In some decisions, these analyses were intermingled, meaning that both histories of victimization and Gladue factors were effectively considered together. In other decisions, the Gladue analysis was only superficial, such as where the judge indicates that they considered Gladue factors but do not explain what that means in concrete terms, regarding how they considered Gladue factors and how that affected their reasoning on sentence determination. Essentially, some decisions more successfully contextualize the Aboriginal women's criminal activity within Gladue factors and against their histories of victimization, and some decisions demonstrated more individualized, decontextualized thinking. So I'll start to conclude now. I've spoken positively about conditional sentences in the sense that I've suggested they should be a necessary part of giving real force and effect to the sentencing provisions, directing judges to use restraint when sentencing generally, and particularly for Aboriginal offenders. I've also suggested that conditional sentences are a particularly important option for criminalized Aboriginal women who might otherwise be ordered to a term of incarceration in closed custody. I do want to note that there are dangers for Aboriginal women in the conditional sentencing regime as well. Research has shown that Aboriginal women breach the conditions attached to their conditional sentencing orders nearly 3 times more than non-Aboriginal women breach. There may be many reasons for this, and this dynamic too must be considered against systemic factors, and particularly colonization. But because the presumptive consequence of breaching a conditional sentence order is for the offender to serve the balance of the sentence in prison, restrictive conditions such as abstinence conditions for a woman who has a history of substance abuse can mean the woman will end up in prison anyway, so set up to fail in a way. These are the kinds of stories that create the cycle through the proverbial revolving door. Conditional sentences may also be dangerous for women who are ordered to serve their sentences in their home if they live with an abusive partner. Conditional sentences may also be problematic or impossible for women who are homeless or otherwise insufficiently housed or living in poverty. Conditional sentences are designed to be punitive and restrictive, and the Supreme Court has emphasized this. So altogether, conditional sentences carry problems with them as well, but I still believe that they must be part of the available sentencing options, and particularly for Aboriginal women, both to reduce community and family disruption and destruction, and also to play a role in the amelioration of the overrepresentation of Aboriginal women in prison. In the Supreme Court decision in Gladue, Justices Corey and Iacobucci comment that sentencing judges have a limited role in remedying injustice against Aboriginal peoples in Canada. Sentencing is near the end of the line in many ways, and too late, in terms of a woman's trajectory through and being enmeshed in a variety of state institutions. But judges nonetheless have a role to play, and I believe sentencing judges need ample discretion to truly be able to exercise that role in a meaningful way for Aboriginal women. This implicates the politics behind the legislation in terms of their ideological underpinnings and motivations. But criminal justice initiatives alone will never heal Aboriginal communities or reduce over-incarceration. We need greater and more accessible community resources, more culturally appropriate community resources for Aboriginal women, and we need political will and funding, and we need movements toward decarceration and strategies that are resourced. Most significantly, we need to let Aboriginal communities determine their own needs and how to achieve those needs, which may mean self-determination and self-governance. In the meantime, we need to stop criminalizing Aboriginal women for the ways that they navigate, cope with, and survive within the impacts of colonization and gendered victimizations. I'm just going to close with comments by Fran and Lana in their research accompanying the report by the Task Force on Federally Sentenced Women called Creating Choices. Fran and Lana have written, "The women inside have the understanding to help ourselves. And all that is required is the right kind of resources, support, and help. They explain that Aboriginal people must be at the center of this, a healing process premised on our need to heal and to walk in balance." So that concludes my comments, and I think we're running short on time. Yeah, I can see people are tired. I'm tired too, I understand. So if you have questions, I'm welcome to hear them, or if that's it, that's fine too. So there you go.
Well, if there are any burning questions, ask them, recognizing that I know that your time is cut short because the previous panel went over, but if anybody has any questions for Elspeth?
I can exchange email addresses with you, and we can talk about that. It's not in a form yet that I want to circulate, but... Actually, when I found out this was being recorded, it's like my nightmare, but anyway.
Just so you know, I sent your parents a notice to watch.
Okay, thanks.